The YSL RICO trial is spiraling out of control. The state has filed a response to defense motion to recuse Judge Glanville, and Young Thug's lawyers filed a motion for mistrial listing several examples of prosecutorial misconduct. Yeah, this might be the worst response that Miss Love could have ever done. She's on the same level of delusion as Judge Glanville, thinking that everything was proper in this ex parte meeting, and that the defendants didn't have a right to be there. Absolutely mind-boggling. Hit subscribe, here we go. Alright, so here it is. State's response to defense motion to recuse Judge Glanville in the trial of the above-styled case. Midway through this months-long trial, defendant Jeffrey Williams and Diamante Kendrick each filed a motion to recuse Glanville, and defendants filed a supplement to the motions, the video I made yesterday, the supplement video. The state recognizes that Chief Judge Glanville has reassigned the motion and has been properly assigned to this honorable court. State respectfully submits that at the time of the reassignment, Chief Judge Glanville did not make the three requisite determinations: whether the motion was timely filed, whether any affidavit made in support of the motion is legally sufficient, and whether if some or all of the facts set forth in the affidavit are true, recusal is authorized. As set forth below, the defense motion and supplement are in part timely, and the affidavits in support of the defense motion and supplement are in part legally sufficient. None of the facts set forth in defense affidavits, even if assumed to be true, would authorize recusal. Defendant's motion and supplement should therefore both be denied. We all know the state would want to deny this. This is something we all expected. Factual background: the calling of state's witness Kenneth Copeland on June 7th. On June 6th, in response to an inquiry from counsel for the defense in this case, the state announced that Kenneth Copeland would be the state's next witness and would be called on June 7th. After the announcement, state received an email from John Melnick claiming to represent Kenneth Copeland and instructing the state to cease communication with Mr. Copeland, and that Copeland will be asserting his Fifth Amendment privilege if called to testify on June 7th. Perplexingly, given that Mr. Copeland was being called to testify against Jeffrey Williams and Shannon Stillwell, who were represented respectively by Brian Steele and Max Sharp, Melnick copied Brian Steele and Max Sharp on his communication with the state regarding Mr. Copeland's intention not to testify. Woody's lawyer adding in Brian Steele and Max Sharp in the email. This makes Miss Love freak out and think that he's doing this in their best interest. She even thought it was a mistake. In preparation for trial, Deputy District Attorney Hylton, along with her investigator, had met with Mr. Copeland on multiple occasions, and at no time did Mr. Copeland state an intention to plead the Fifth or say that he was represented by Mr. Melnick. Nevertheless, after receiving Mr. Melnick's email, Hylton ceased communication with Mr. Copeland until June 7th. Pursuant to OCGA 24-5-507, after receiving Mr. Melnick's email, the state presented to Chief Judge Glanville a motion to compel the testimony of Kenneth Copeland, extending immunity to Mr. Copeland for his testimony and to hold Mr. Copeland contempt should Mr. Copeland refuse to testify after being ordered to do so by the court after being granting immunity. The court issued an order granting the state's motion. So this is forced immunity. They don't want Woody to be worried about, incriminating himself on the stand. This immunity makes Woody stay in jail if he pleads the Fifth, basically. On June 7th, 2024, after court was called to order, Mr. Melnick appeared before the court and informed the court that Kenneth Copeland would be asserting a Fifth Amendment privilege against self-incrimination. In the presence of each defendant currently on trial and each of their respective attorneys, Chief Judge Glanville called Mr. Copeland to the stand and explained to Mr. Copeland that the state had sought and been granted an order of the court pursuant to OCGA 24-5-507, directing Mr. Copeland to testify and extending immunity for Mr. Copeland's compelled testimony. Chief Judge Glanville further explained to Mr. Copeland in the presence of every defendant currently on trial and each of their respective attorneys that should Mr. Copeland refuse to testify, he would be held in contempt of court and jailed until he purged himself of the contempt by testifying in court. I still think that's insane that they're allowed to do that. I mean, it's basically threatening jail time for years if he doesn't testify. Mr. Copeland thereafter stated his intention to testify, and Mr. Melnick looked toward Mr. Steele and Mr. Sharp and shrugged his shoulders. So that's when she was saying that she thinks Mr. Melnick was like, well, I tried to get him not to testify. Sorry, guys. After motion hearings, the court recessed for lunch. During the lunch hour, Mr. Melnick spoke with counsel for the defendants, but at no time attempted to communicate with the state. After lunch, the jury was called in and Mr. Copeland took the stand. Mr. Copeland cheekily answered a few questions, and when asked his age and years, Mr. Copeland responded, "I plead the Fifth." The court allowed no further questioning by the state and immediately excused the jury. Held Mr. Copeland in contempt and ordered Mr. Copeland in custody. In open court, in the presence of all the defendants currently on trial and in the presence of each defendant's respective attorneys, Glanville informed Mr. Copeland and Mr. Melnick that he would bring Mr. Copeland back into court on Monday, June 10th, to allow Mr. Copeland to purge himself of his contempt by testifying. Mr. Melnick announced that he was going on vacation, would in no way be present on Monday, and would appoint stand-in counsel Caleb Bumpus to represent Mr. Copeland in court. June 10th, 2024, a meeting regarding contempt proceedings initiated against Kenneth Copeland upon motion of the state, attended by counsel for Kenneth Copeland, attorneys for the state, Kenneth Copeland, and the Honorable Chief Judge Glanville. So this is about the ex parte meeting now. On Monday morning, prior to the start of the court, the state requested from the court an in-chambers meeting with the counsel for Kenneth Copeland and Kenneth Copeland, the court, an attorney for the state, to discuss the contempt proceedings initiated against Mr. Copeland upon the state's motion. The court granted the state's request upon being directed to do so by the court, and the court reporter made record of the entire meeting. Present during this meeting was Miss Love, Caleb Bumpus, investigators for the state, and the Honorable Chief Judge Glanville, and later Kenneth Copeland and DDA Hylton. Matters addressed during this meeting concerned only the contempt proceedings against Mr. Copeland, and the topics addressed included topics Mr. Copeland's rights and representations as it relates to the proceedings, Mr. Copeland's obligations under OCGA 24-5-507, answers to the question questions posed by Mr. Copeland regarding matters related to that, such as the distinction between purging and perjury. With the exception of the times where Mr. Copeland was afforded an opportunity to speak with Ms. Bumps alone, the entire meeting was taken down by the court reporter. See, the defense lawyers say there's some holes in the court reporter typing shit out. Like maybe she just wasn't present in the room and other shit happened. But it's funny, Miss Love has not addressed that basically the judge was also helping her, giving legal advice and telling Woody certain things that an unbiased judge would never do, obviously. Brian Steele's defiance of the court's commands and subsequent contempt ruling. There's no way she defends Brian Steele being held in contempt. There's no way. There's no way anyone can defend that. That was a complete error in judgment by Judge Glanville. If she does that in here, I'm going to be mind blown. After the meeting regarding Mr. Copeland's contempt and obligations, Brian Steele stood in open court and demanded a mistrial as he loudly and repeatedly hurled at Chief Judge Glanville accusations of misconduct. Most disturbingly, oh boy, after accusing the court of illegal activity, Mr. Steele repeatedly disobeyed the Chief Judge Glanville's commands to reveal that Mr. Steele's source of information regarding the in-chamber matters. After Mr. Steele refused to comply with the court's instruction, the court held Mr. Steele in contempt of court. After defiantly and repeatedly disobeying the court and being held in contempt of court, Brian Steele filed the motion and supplement. This tone that Miss Love, I hate her. I'm sorry. I know we all expected this tone from Miss Love because that's just the way she is in court. How on earth is she defending that? Part 3, argument and citation of authority. No quote-unquote fact set forth in defense motion or supplement authorizes the recusal of Chief Judge Glanville. But didn't he have a meeting with a sworn witness, hid Brady evidence and didn't disclose it, and threatened him with years of jail if he didn't testify? To warrant disqualification of a trial judge, the affidavit supporting the recusal motion must give fair support to the charge of a bent mind that may prevent or impede impartiality of judgment. If you're asking me, Glanville's mind was bent as fuck. To be disqualifying, the alleged bias must stem from an extrajudicial source and result in an opinion on the merits on some basis other than what the judge learned from his participation in the case. Emphasis added. Wait, Miss Love thinks she's putting bold letters in here, gonna change shit. There is a presumption that a trial judge acting as a public official faithfully and lawfully performs the duties devolving upon him. Determining whether an affidavit supporting a motion to recuse is legally sufficient and whether the facts asserted authorize recusal present questions of law. Here, with the exception of the defendant Williams' untimely allegation regarding a single instance where Mr. Steele was chided by the court for not being prepared, defense motions and the supplement are based entirely on the defense assertions regarding June 10th meeting regarding the contempt proceedings against Copeland and actions taken by Glanville after Mr. Steele defiantly refused to comply with the court's repeated request to provide the court with the information. So now Miss Love is using the word assertion like Glanville does. It's not an assertion when it's on paper. We have the transcript. There's several examples of misconduct in the transcript. End of story, bottom line. This isn't a fucking assertion. Isn't this ironic? She's starting to cite the Judicial Code 2.9 regarding ex parte communication provides that judges shall accord to every person who has a legal interest in a proceeding, or that a person's lawyer the right to be heard according to law. However, no defendant on trial in this case had or has any legal interest in or any standing to be involved in the state's motion to compel the testimony of Kenneth Copeland or any subsequent contempt proceedings initiated on the motion of the state involving Kenneth Copeland's refusal to testify. Apparently, a state's witness that's their star witness being coerced to testify is not important to the defense. That's basically what that just said. What world are we living in? That's pure delusion. It's their star witness. This guy snitched on everyone. He puts multiple people in the car that killed Donovan Thomas Jr. What are we doing here? This is literally delusion. Since no defendant in this had a right to be present at June 10th in Chambers meeting with Kenneth Copeland and his counsel regarding the contempt proceedings against Kenneth Copeland, the fact of the meeting provides no grounds for recusal of Chief Judge Glanville. Respectfully submitted by Adrian Love on July 10th. I'm fucking baffled. That is literally the worst response I've ever seen. This is literally dog shit compared to Brian Steele's supplement yesterday. Brian Steele's supplement was like, I think it was like 50 pages. This was like 8 or 9 pages, and it just repeated the same delusion that it's all assertions and it's not true when we all see it in fucking writing. Miss Love, I hope you're watching this. This was the worst response I've ever seen. This was terrible. So one of the exhibits in this is the email with Melnick. Melnick said, "My concern is for my client. Had I been involved, I would have demanded a much more specific immunity deal. You need him much more than he needs you. You've put him in a terrible position where you know his life is in danger, whether in custody or on the street. He's a marked man from this point forward. Go fuck yourself if you think I'm doing anything besides protecting my client." And that was in response to her saying, "Is your concern for your client or for Mr. Steele's and Mr. Shart's?" And she has an African proverb underneath every email and her pronouns. I'm not going to get into any of that, dude. Shout out Thugger Daily. Like always, Young Thug's lawyer files a motion for a mistrial, barring retrial based on prosecutorial misconduct. The motion lists many instances of alleged prosecutorial misconduct, beginning with Miss Love directly violating a court order with no consequences on day one of the trial. So I think that's maybe when Miss Love showed slides and opening statement that were never handed over to the defense. And remember, on the first day of this trial, Brian Steele motioned for a mistrial because this shit's been a goddamn disaster since day one. So here's this motion for a fair trial, as well as a motion motion for a list of dates/persons who participated in any ex parte communications with the court, and the topic of same motion for mistrial based upon judicial and prosecutorial misconduct, and thus bar retrial. Mr. Williams is innocent of all crimes. From the inception, this trial has been constitutionally unfair, as this court has failed to be impartial to Mr. Williams, and his counsel has been objectively biased in favor of the prosecution. Some examples of some include, but are not limited to, the below. Prior to opening statements, this court ordered all parties to share with each other any demonstrative aids they would seek to display to the jury during opening statements back in November. And he links the YouTube stream where Ms. Love straight up just didn't give over slides. So that's the first strike. During the same opening statement, Lawyer Love defied another court order by introducing to the jury that undersigned counsel had represented other people charged in this case. Oh yeah, I forgot about that. She showed the jury that Brian Steele represented, I think his name was Mr. Blaylock or something like that. Lawyer Love highlighted to the jury undersigned counsel representing co-indictee Blaylock. Again, there was no consequences. So he's just listing everything Love is up. Lawyer Love accused undersigned counsel of knowingly and intelligently misrepresenting to the jury that witness Mr. Bean was taken to Grady Hospital by police directly from the scene of his arrest on September 11, 2013. At a bench conference, Lawyer Love falsely stated that she had evidence on her table to prove that undersigned counsel fabricated evidence that Mr. Bean never went to Grady Hospital. These allegations were proven beyond any reasonable doubt to be totally knowingly false. Yet the court did not admonish Lawyer Love all for falsely accusing another member of the bar of being untruthful. The state was attempting to introduce January 26, 2015 social media posts from co-indictee Garlington's account. During the testimony, Detective Gaither, Lawyer Love, told the court that only Mr. Williams' voice could be heard on this video, except for one of the voice saying the words like "yeah" in the background. Counsel told the court that Love was incorrect and that several persons' voices were audible in the social media posting. Lawyer Love continued to falsely accuse counsel of misrepresenting facts to the court. Of course, Lawyer Love was proven to be untruthful in her false allegation of wrongdoing. Although it was objectively proven that Lawyer Love falsely accused another member of the bar misconduct lying to the court did not admonish Lawyer Love. This is just a terrible look for Fulton County, dude. The state completely botched this case. And now we're fast forwarding to the present time. Lawyer Love falsely accused undersigned counsel of purposely extracting and tampering with jail recordings of Mr. Copeland. This was another knowing, malicious, false allegation by Lawyer Love. This court remained mute and failed to admonish Lawyer Love. This one's about Miss Love falsely accusing Mr. Melnick of being in the defense's interest. In the jury's presence on separate occasion, this court wrongly accused undersigned counsel of being unprofessional as well as unprepared. I remember that. That was bad. The judge said straight up in front of the jury that Brian Steele was unprepared about something. I don't remember when it was, because I think this, yeah, it says it was back in March. That's insane to say that in front of a jury. Both allegations are completely false, yet the court's bias is so deep that the court refused to instruct the jury that court's declaration was completely wrong. The court's impartiality is objectively questioned. The court must be recused. See Johnson versus State. Again, they've cited this case a lot. The unprofessional and unprepared accusations from the court. This conduct shows the court is biased against Mr. Williams and favors the state, as no unbiased judge would not correct such serious misstatement made in front of the jury. Mr. Williams languishes in jail without bond since May 9th, 2022. Mr. Williams has been and is being denied his constitutional rights to due process, a fair tribunal, and a fair trial based on prosecutorial misconduct and judicial misconduct. This court has exhibited a pattern of behavior in favor of the state and against Mr. Williams. Here's Brian Steele saying the court has become part of the prosecution team again, and now he's citing the ex parte meeting again. And now they want every ex parte meeting that they've had since the beginning of the trial, because obviously we don't know where this starts or ends. The defense lawyers now don't know if they've been doing this with other witnesses like Adrian Bean or Trontavious Stephen. Those two guys didn't want to be in there. You think they were pretty easy to convince to go up and testify? Probably not. They probably had some ex parte meetings with those guys, honestly. And Thugger Daily also tweeted that Brian Steele added Hylton, Love, and Glanville to the witness list. This trial's not going on, bro. That's never going to happen. It's not possible. There's no way that they can salvage this trial. It's too far gone. On a side note, you've had the best coverage of this thing. Yes. Thugger Daily, I'd be lost without Thugger Daily. My videos wouldn't be anywhere near as good without Thugger Daily, so go follow him. Follow me on everything too. Hit subscribe. That's it for today, I think. Join the channel membership. It's only 10 cents per day. I appreciate the support more than you guys will ever know. Love you guys. Peace out.